that if we want to best understand the agency budgets that are before us and best understand how to craft a fiscal year 2026 budget. And I will just remind everyone that the council is the one that appropriates. We are the ones who adopt the budget, that these documents ought to be made available. And I find it puzzling that the executive not only, the executive continues to insist that it doesn't have to release these documents. In fact, at this point, it's just ignoring the council since I sent that letter on June 6th. And that we would be within our rights to pursue a order from the court because clearly the court and the law are on our side here. So I just wanted to put that on the record, and I'm happy to discuss that further with any member. And I believe I sent copies of that letter to all the members, but be happy to send it again if you want. That concludes the business of this committee of the whole. The next legislative meeting, well, we have the additional meeting after this, and then the next regular legislative meeting will be July 1st, and there likely will be a committee of the whole meeting at that time as well. The time is 1:08 p.m. We will start the legislative meeting in 5 minutes or sooner if we're ready. It's 1:08 and we are adjourned.
Nay.
I'm calling to order this meeting. This is a legislative meeting of the Council of the District of Columbia. It's an additional meeting. That is, it's not a regularly scheduled meeting. I'm Phil Mendelson, Chair of the Council. Today is Tuesday, June 17th, 2025. The time is 1:20 in the afternoon. And we are meeting in room 500, the council chambers of the John A. Wilson Building. This meeting is being televised and is available on Council Channel 13, as well as the council's website, www.dccouncil.gov. We always begin our legislative meetings with a moment of silence. I'm getting a little choked up. I shouldn't be, but I wanted to note some members here knew one of the Minnesota legislators who was assassinated over the weekend, Melissa Hortman, who had been active in the National Conference of State Legislatures. Councilman McDuffie, I think you and I both met her at one of the meetings, and she was also active with the Uniform Law Commission. And so our commissioners had worked with her on a number of uniform laws. So even though it's the state of Minnesota, which is far from the District of Columbia, these things can hit close to home. So I just wanted to note that as we have a moment of silence. Madam Secretary, would you call the roll?
Councilmember Allen.
Here.
Councilmember Bonds. Here. Councilmember Felder.
Here.
Councilmember Freeman.
Here.
Councilmember Henderson.
Here.
Councilmember Lewis George. Present. Councilmember McDuffie.
Here.
Chairman Mendelson.
Present.
Councilmember Nadeau. Here. Councilmember Parker.
Here.
Councilmember Pinto. Present. Councilmember White. Councilmember White.
Present.
Mr. Chairman, you have a quorum.
Thank you, Madam Secretary. We have the consent agenda. Are there any changes to the consent agenda?
Mr. Chairman?
Yes.
Mr. Chairman, I would like to withdraw B26269, the Family Rehousing Stabilization Program Protection Temporary Amendment Act of 2025 from the consent agenda. I will be moving to postpone this measure indefinitely. Motion to postpone.
That's item F1 on page 2, correct? Bill 26-269.
That's right.
Other changes? I have 2 changes. No, I have 1. On page 1, item B2, a final reading on Bill 26-62, Board of Trustees Training Amendment Act of 2025. And then I want to remind members, Councilmember Parker asked that Bill 26-189, the Residential Tranquility Amendment Act, not be on consent. So that's off of consent. So to review, we have 3 measures that are not on the consent agenda. Board of Trustees Training Amendment Act, Bill 26-62. Residential Tranquility Amendment Act, Bill 26-189. And Family Rehousing Stabilization Program Protection Temporary Amendment Act, Bill 26-269. If there are no other changes to the consent agenda, the vote will be on the consent agenda as amended. All those in favor say aye. Aye.
Aye.
Aye.
Are there any no votes? The ayes have it unanimously. The first measure for consideration would be, so I'll go through the 3 formerly consent agenda items. Bill 26-62, Board of Trustees Training Amendment Act of 2025, so moved. Without objection, I'm going to postpone this to July 1st legislative meeting. Is there any objection? Hearing none, it's postponed to July 1st. Next, we have Bill 26-189, Residential Tranquility Amendment Act of 2025, Councilmember Pinto.
Thank you, Mr. Chairman. I spoke at length to this a couple of minutes ago, but for the record, this is a permanent version of a bill that the council passed on an emergency and temporary basis last fall for a very limited set of circumstances for amplified devices, whether they're left unattended, if it is a residential zone for a protest targeting a residence overnight using an amplified device, or throwing projectiles into people's homes for harassment or retaliatory purposes. And I ask that my colleagues support this measure today. I do want people to know how careful and conscientious we were in the developing of the language of this bill, that it is extremely narrow. I and we all value the district's rights to First Amendment protest and assembly, and that will continue to be supported. Since the passage of the emergency bill last fall, this has been used a limited number of times to protect these late night protests with amplified devices, but 0 arrests have been made. And that is my expectation moving forward. But the police do need a tool to be able to tell people they've got to move on if these amplified devices are used overnight targeting a residence in a residential zone. Thank you.
Thank you. Is there discussion? The vote will be on the bill, Bill 26-189. All those in favor say aye.
Aye.
Are there any no votes?
Mr. Chairman, please record me as no.
Record Mr. Parker as no. I didn't hear you.
Yes, that was correct. Please record me as no.
So the ayes have it. Mr. Parker will be recorded as no. The next measure is Bill 26-269, Family Rehousing Stabilization Program Protection Temporary Amendment Act. Councilmember Fruman.
Mr. Chairman, the Committee on Human Services will be recommending that the council adopt a BSA subtitle proposed by the mayor that would be inconsistent with this legislation. The emergency version of this legislation will likely be superseded by the emergency version of the BSA, and I would not support a temporary that would be inconsistent with the committee's recommendations. Accordingly, I move to postpone the consideration of this measure indefinitely.
There's been a motion to postpone this indefinitely. Is there discussion on the motion to postpone indefinitely? All those in favor say aye.
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 Are there any opposed? The ayes have it unanimously. Turning to the non-consent agenda, the first measure is Bill 26-48, Review of Agency Action Clarification Amendment Act of 2025. So moved, and I'm going to move to postpone consideration to July 1st. There's no objection.
I have a strong objection to Bill, I'm sorry, to which bill?
All of the rest of the agenda? No. Bill 26-48.
What's the title of that bill?
The Review of Agency Action Clarification Amendment Act of 2025.
I respectfully withdraw my strong objection.
If there's no objection, the consideration will be postponed to July 1st. Hearing no objection, it's so ordered. So next on the agenda is Bill 26-187, Metropolitan Police Department Training Academy College Credit Opportunity Amendment Act of 2025, which is now known as the Peace DC Omnibus Amendment Act of 2025. Councilmember Pinto.
Thank you, Mr. Chairman. This bill seeks to do several things. We really tried in developing Peace DC to focus on 4 categories: empowering our young people, preventing violence, supporting our public safety workforces, and reducing recidivism. And this seeks to address all of those categories and important topics. A few things that this is focused on is expanding the presumption for survivor benefits when our firefighters or emergency response workers die as a result of a condition that they got on the job. So this is like if a firefighter is exposed to smoke and then develops lung cancer, to make sure that their survivors are supported in their benefits, making permanent the pretrial detention presumptions for the most violent crime. I have made some changes to this print to remove robbery where there is not a significant harm to human life, and second-degree burglary. MPD credits, which I have an amendment for today, which I will be accepting as friendly, but I hope others can support, and that addresses the concerns that colleagues have raised to allow MPD officers. They're still required to have 60 credits, but the last 20 of which can be earned if MPD enters into an agreement and a partnership with an accredited university to accredit their training academy. Changes to empower our special police officers in WMATA, who already, this is a really important point, already have the authority to handle criminal issues. If someone brings a weapon or something like that onto the system, they are trained to de-escalate and deal with this, but they don't have the authority to write a civil ticket. So it's just giving them the civil authority to write a ticket. As of December, 75% of people still weren't paying their fare. I know we'd all love to have a system in DC where we had a free transit system, but where we are today, that is not the system we have. And so people have to pay their fare, and we need to have an enforcement mechanism to do so. And this would empower SPOs to help in that effort. And changes to our record sealing laws to fix a gap that was inadvertently created from a previous bill to make sure that those with less serious offenses can still apply to have their records sealed. So I hope I can have my colleagues' support on this today. It's my understanding, Councilmember Lewis George, that you may be withdrawing your MPD credit amendment, but if you have another amendment you want to speak to, I can hold my response for that.
Thank you, Councilmember Pinto. Give me just a second.
She was referring to Lewis George first to see.
Councilmember Pinto, I did not pay attention for a second. You have an amendment, and you're the sponsor of the bill. Did you want to move the amendment?
Yes, I would.
Then you have to say so moved.
I would like to move my amendment dealing with the MPD credit hours. Up to 20 hours could be certified. This was circulated yesterday afternoon. So moved, Mr. Chairman.
Circulated at June 16th at 6:05 p.m. Does that sound right?
Yes.
Okay, so we have that amendment before us. Is there discussion on the amendment?
Mr. Chair.
Councilmember Allen.
Thank you. Councilor Pinto, I want to thank you for offering this amendment. When we were at the committee markup a week ago, this was one of the elements that I raised as concerning because as the committee print was drafted, it in essence treated the existing training academy as about 75% of those college credits needed, with the ability to create a course for the final 25%. In talking with former Councilmember Kathy Patterson and many others, there's a reason why the city created an expectation of the 2 years, in essence, of college credits. And I think we heard from police chiefs, I know I heard from police chiefs for years, that they would say there'll come a day as police staffing numbers go up and go down, that you'll be tempted to reduce your standards, reduce the expectations because you just want to get people in. They said, when that happens, don't do it. And that was my concern, was that we were going to be taking a step that in essence eliminated that education requirement. I think your amendment strikes a really good balance because there are individuals who started college, but life happened. They had a kid, ran into financing trouble, weren't able to get the credits. And I think what this does is help set up a pathway to be more of that gap filler, that bridge for someone who has college credits, but can't meet the 60 credit requirement yet, and it helps them get in. So I am going to be supportive of this amendment because I think it really does match the spirit of what I talked about and what I think others have talked about and actually is not too far from what your original introduced version was as well. So I think that's the right approach, and I appreciate that. I would like to make sure between now and second reading, we continue to fine tune perhaps a little bit more. One of my questions, and I'll certainly give you time to answer this, I believe the way this is crafted, we are giving MPD the authority to create whatever this additional credit program is, but it doesn't require any approval by us. And it's a little unclear. They say they're just going to absorb the costs. I'm not entirely sure how much that's actually going to cost. Understandably, magically, when agencies really want to do something, they find a way to absorb the cost. But does this require any additional step by the council to approve this new system? From my understanding, when UDC, for example, looked at our own training academy, my understanding is that it was going to count for about 25 credits, 15 credits. They then found another university that looked at the exact same training academy and said that would count as 45 credits. So a bit of a disparity there. And I think one of my colleagues brought this up, and I share her concerns. So just want to make sure that we have eyes on what that looks like. And perhaps that's also something to address between first and second reading. But again, I support your amendment here. I think it's definitely headed in the right direction and appreciate the spirit that you've put this in.
Further on the amendment? Councilmember Lewis George.
Thank you, Chairman. I want to also thank Councilmember Pinto. Originally, when I had introduced an amendment based on the original print, it was because of my belief that maintaining educational standards is really essential to professionalizing law enforcement and ensuring our officers are well prepared for community policing. Higher education requirements really do develop critical thinking skills, cultural awareness, and broader perspectives that benefit both officers and the community they serve. And I think that's an important thing that we must maintain. And so I know that there is a recruitment challenges that we are facing as a district, and I appreciate that Councilmember Pinto is really trying to address those recruitment challenges. I know that educational qualifications was, I think, the second least common reason applicants are deemed ineligible, but it's important that we still try to address those recruitment barriers. And so I think your amendment strikes the right balance, and as such, I will be supporting your amendment, withdrawing my amendment. Thank you, Chairman.
Thank you. Further on the amendment? Councilmember Robert White.
Thank you, Chairman. I appreciate what this amendment is intending to do. What I worry is that so often in criminal justice, we make assumptions without data to back it up, and then we move forward. The idea that college credits professionalize is an outdated way of thinking. Increasingly, people are not going to college, not because they're not smart, but because it's not a good investment for a lot of people. So to have a bar that has nothing to do with the work required is really concerning, particularly as we need to increase the number of police. In fact, I consulted some years ago with a very seasoned officer who for a long time ran a high-level training academy in the country, and he told me, and this is when my thinking on this changed, he said, I would hire a manager from Popeyes over somebody with a college degree every day because that person has proven that they know how to deal with difficult situations, and that's not what you learn to do in college. So I think in policing and across the board in other professions, we have to move away from this thinking that a college degree somehow prepares you when it doesn't. And so while we're talking about this, I just want to remind us that there is no known correlation today between college credits and your success as a police officer. And in fact, I think we should move away from that and look at the things that will actually make good police officers, including, I don't know what the age requirement is, but certainly a minimum age requirement. Thank you, Chairman.
Thank you, Councilmember White. So I'm going to speak to this. I'm very concerned about this proposal in the bill. I appreciate that the amendment improves what's in the bill, but I would say I'm still not satisfied. That does not mean I will vote against it today because I think this amendment is an improvement. But I will say, with all due respect to my at-large colleague, I have in front of me 8 citations, that is 8 different articles that speak to the benefit of higher education with regard to policing. For example, a study done in 2012. Use of force in minority communities is related to police education, age, experience, and ethnicity. Or a 2020 study, education level and police use of force, the impact of a college degree. Or here's another one, the effect of higher education on police behavior. There have been studies after studies after studies that have correlated the benefit of higher education on better policing. We used to, as a city, be proud of the many different ways that we were a gold standard in our approach to things. For instance, with environmental policy and the many bills that the council has passed, we discussed that this morning. But here, with regard to police conduct, here was again a gold standard where we have this educational requirement that we are now asked to relax. And the consequences of relaxing the standard are consequences that are not seen next year, but are seen over the next decade or two, where we see instances and increased instances of the misuse of police force, for example, or disproportionate policing on minority communities, for example. We ask a lot of our police officers because they have to do more than just simply catch robbers. A lot of the work that they do is community relations, is social work, is de-escalation. It's so much, and that is why education is important. And again, I just want to emphasize the research is ample and broad and numerous with regard to this correlation. The council adopted the current requirements back at the beginning of about 25 years ago. Don't want to say how long ago, but adopted them because of the abuses that we were seeing in the police force in the 1990s. And in fact, I remember the council going through a protracted and difficult debate because originally the requirement, I believe, was 4 years, and we lowered that requirement to what's currently the law. But we will see the consequences from relaxing these standards. Oftentimes as a council, we try to find a path that we can agree to that moves forward, but this is one where I just have to say, this is so important and fundamental to quality policing, what I referred to as the gold standard. We should not be relaxing the standards. I don't know that it will have much of an impact on recruitment, but even if we got more officers, are we going to get more instances of bad cops? That's what we corrected 20 years ago with the current law, and we should not go back there. So I will vote for this amendment today, but we'll be looking at this with colleagues between now and second reading, because this is too important. We want a quality police force. That was recognizing everybody who asked to speak on this. We have the amendment before us, Councilmember Pinto's amendment. Mr. McDuffie.
I'm going to make my remarks brief and recognize the remarks by my colleagues in the varying positions. I think education is important, and I think there's a lot of research that suggests that education and policing is important. But I also think that it's important that we have officers who reflect the communities within which they work and within which they are charged to protect and serve. And as we think about what education requirements are, we also should be thinking about how we're educating the people in this city to be able to compete for those jobs. Disparities and gaps exist in education across the country, and it's no different in the District of Columbia when it comes to race. And if you look at where our police force is today in 2025, I would venture to say, I don't have the data in front of me, and I'm happy to be corrected, but the percentage of African-American officers, I suspect, is down significantly than when it was in the 80s and 90s, the period of which you were referring to earlier. We're sending more of our kids to college in the District of Columbia, which is something we should be proud about, but there continue to be significant gaps between graduation rates between our white students and our black students. And we should be worried about that. We should be worried about how many kids are graduating from our high schools in DC going off to college, and how many of them are desire to actually pursue law enforcement as a career. I think it has something to do with the way that policing has impacted communities of color over the last several years. I think we have turned, or we are on the verge of turning the page on some of the horrible things that happened 5 years ago, but we have some ways to go. I'm only saying this to say, but I think my point is that while education is important and we should have education requirements in the people who we swear to serve and protect as MPD officers, we cannot forget the barrier that it creates in certain communities, particularly communities of color, and how that impacts policing in the District of Columbia. If we want our police force to really reflect the values of the people who are in our city, then we need to make sure that we continue to maintain a diverse force in terms of our hiring. I know it's not in vogue to say that these days, but I think it's absolutely critical that we not forget that recruiting is a huge part of what I think ultimately makes a police force look good and police force effective in its ability to de-escalate, understand, have cultural competency, and be able to go across a very diverse city in order to do their jobs well and safely.
Thank you. The vote will be on Councilmember Pinto's amendment. All those in favor of the amendment say aye.
Aye.
Opposed? The ayes have it unanimously. I see that Councilmember Pinto, you had no other amendments, correct? Correct. Councilmember Lewis George, you had an amendment?
Yes. Thank you, Mr. Chairman. I introduced this amendment alongside Councilmember Allen because this bill expands special police officer authority on public transit without proper public input. This provision never received a public hearing. Our community input process that our residents deserve on matters affecting their daily lives. Additionally, special officers lack the oversight, training, standards, and accountability mechanisms of sworn officers. Yet, this bill grants them citation and arrest powers that could lead to federal prosecution through the current U.S. Attorney's Office. The potential for disparate enforcement outweighs any claimed operational benefits, which is why I believe this provision must be struck. Additionally, there are also procedural hurdles that need to be worked out with this bill, which is why it should have gone through a proper public input and community input process, because some of the procedural issues that were raised this morning at our breakfast regarding the Office of Administrative Hearings, regarding potential prosecution limitations is another factor. And so with that, I move the amendment and ask for my colleagues' support.
We have the amendment before us. Is there discussion? Councilmember Henderson?
Thank you, Mr. Chairman. I'm going to be supporting Councilmember Lewis George's amendment. There are lots of questions I had in terms of how this provision about SPO kind of got in there, but you know, in the intervening time that we were discussing one of the prior bills that was being moved today on safe passage, I just want to note, so in the FIS for safe passage, which has already passed, but in the FIS, the Office of the Chief Financial Officer noted that we were adding 56 additional hours for safe passage. I just want to note that that is more hours of training than a special police officer, which we are now going to be putting on Metro to be able to engage in the public and also start to issue citations, which the Office of Administrative Hearings has already noted that WMATA has had difficulty issuing citations that had legal sufficiency in order to be able to move forward. So I feel like if this is something that we really feel like is necessary, it deserves an opportunity for a full hearing and a discussion about what is the best way to move forward, as opposed to us just assuming that every person who is a SPO is somehow this immensely talented and qualified and trained individual, when in fact, that is not always the case. Thank you.
Thank you. Councilmember Allen?
Thank you, Mr. Chair. I'm in support of this amendment, and during the committee markup, this was another element that I had raised a concern around. And let me just walk through briefly what those are. I mean, this is an expansion of police powers that has not had a public hearing. So from the standpoint of just process alone, I think when we talk about expansion of police powers, it benefits by having a public hearing to hear the pros and cons, to let the public weigh in. That's not something that happened here. And so that to me alone says we should not be moving forward with that. When we look at our special police officers, though, we have this would also create different standards of what takes place on the streets or sidewalks of DC or when you're in Metro based on special police officers. So this would grant special police officers the ability to write citations, civil citations within the Metro system, which is not a power or authority that SBOs have out on the sidewalk or in the street today across the rest of DC. So it will create a separation of standards of what SBOs are allowed to do in the district. My colleague also talked about the training. This will create interactions with the public for which the training is not sufficient and is not the same as someone who is a full-fledged officer. There's also lack of oversight. So special police officers are not subject to our own, for example, Office of Police Complaints when it's a special police officer in the District of Columbia. And in WMATA, there's two different types of SBOs. Some SBOs are employees of WMATA, and then there are the majority, which are gonna be contractors. Contracted SPOs do not have a civilian oversight entity. So if someone has an interaction where they feel like they were wronged or this did not go the way it was supposed to, they have no ability to create an oversight mechanism or civilian oversight. That to me is really problematic. And then I will also add, we heard from the leadership of ATU, the union representing the bus drivers themselves, that does not support this language. That is in something that has been kind of wrapped a little bit in this idea of around bus driver safety. The organization that represents the bus drivers is telling us this is not the right way to achieve safety. Make no mistake, every single person on this dais, every single person in this room wants all our bus drivers to be safe. So that is not what's at debate here. Is this the mechanism that achieves that? And ATU has said no. So I am encouraging my colleagues to support this amendment. If this is an idea that WMATA is asking for, then I think they need to try to convince someone to introduce legislation. Let there be a public hearing on it. Let us be able to debate that. But for today, I support this amendment and I do not support this language in the bill.
Thank you, Councilmember Allen. Further on the amendment, Councilmember Pinto.
Thank you, Mr. Chairman. I do not support this amendment today. I think on a lot of the issues that we've debated today, reasonable minds can disagree. And I don't mean to suggest anyone supporting this amendment is unreasonable, but I do want to just highlight a couple things because I've heard some misinformation about some elements here. So one, in terms of public input, this happens all the time. This is an omnibus package. I have not only had 2 days of public hearings in this building where I heard concerns about fare evasion, but I went out into the community. I did walks. I did sessions where we went through all the elements of the bills and talked about this. I visited schools and senior centers and had countless meetings here. And one of the things that I hear from students and from people of all ages is, I don't feel safe riding public transit for a number of different reasons. Or why is it that everybody else is not paying their fare, but I'm expected to pay my fare? We debated this last year when we decided that unfortunately, we don't have free public transit in the city yet. And so we have to have a civil mechanism to collect tickets if somebody violates the law. It's a civil mechanism. It is not criminal. That's already the law. All this is saying is this shouldn't all be on Metro Transit Police to do. We should be using an additional force that's already part of WMATA, that's already doing the more serious criminal offenses. And this is a really important point that if anyone is on the fence, I just want to make sure you hear this point. SPOs are already dealing with people if they're bringing weapons onto the system, or if there's a fight on the tracks, or people have knives or guns. They're trained to do all of that. They're a trained force, but they just don't have the authority to write a civil ticket. That's not a sensible breakdown. I would get it more if this was a whole new idea and a whole new force we were creating. They already have the ability and the training to de-escalate in very serious offenses. So I just want to make sure people understand what we're doing and what we're not doing here. When it comes to the training, I have a commitment from Randy Clark, who runs WMATA, to have 40 additional hours of de-escalation training, so that can continue to be built upon, because we don't want conflicts. We just want people to pay their fine, or pay their ticket. And you could avoid all of this if you just pay your fare. And then in terms of the procedural concerns, this has come up from OAH, from WMATA, from the executive, from people who've been through the process, that we just needed to standardize the approach so that it means something if you get a civil ticket, that you have to pay it. So this is not some huge, broad expansion. I think this is a very sensible way to say, hey, we cannot cost our public transit system $50 million a year because reliability and safety is at risk when we do that.
Thank you, Councilmember. There's no further, Councilmember Furman.
Thank you very much, Chairman Mendelson. You look so disappointed when you saw my hand up. I am trying to parse what changes here, and the idea that an SPO can detain someone, can arrest someone in the context of a criminal setting, and if they witnessed a fare evasion, they could detain that person, hold them until a Metro Transit police person came to issue a citation. I do have a hard time seeing why we wouldn't do this. And I get it that it's an expansion, but it's sort of an expansion it's the inclusion of a lesser power than powers that they already have. And if we're going to address this issue, how are we going to do it just with the number of Metro Transit police that we have? So I'm not going to support the amendment. I hear the debate going back and forth, but it doesn't seem like such a big expansion of powers or something that's so different from what they're doing already. And the kinds of concerns about confrontations, they have to engage in confrontations that would be more challenging than this. Otherwise, they would just be statues in the metro station if they can't confront people and try to deal with situations. So I won't be supporting the amendment.
Thank you, Councilmember Furman. Councilmember Parker.
Thank you, Mr. Chairman. I too sense that disappointment that Councilmember Furman was talking about. I've wrestled with this one because I too care deeply about what's happening in WMATA. Nobody wants our bus drivers attacked. And I do believe fare evasion is a real thing. I would agree, we did talk about this, but I just can't seem to square what's going to be different here. And I welcome Councilmember Pinto to speak to this perhaps, but it seems to me by putting SBOs on buses that are now allowed on the Metro Rail to issue citations isn't going to yield much if the individuals still aren't going to pay the citation and there isn't an enforcement mechanism to make them. I guess the bigger issue for me is, and we've talked offline about this, is we ought to be working to minimize conflict between community members, residents, and armed individuals. The elephant in the room for me is that it's not that it's an officer versus an SBO, it's an armed individual that we are now positioning to be in direct conflict with residents, albeit residents that are fare evading. And it begs the question, is that worth the potential outcome? Is it really worth the potential outcome that someone might lose their life, that there may be disruption and commotion across the system, or are there less disruptive, less dangerous alternatives? And that is what I'm wrestling with. And so I welcome you to speak to that, Councilmember Pinto, if that's allowed, Chairman.
For a minute left of your time, yes.
And the last thing I would just say, last year's debate, we were talking about WMATA police. And there is a difference between WMATA police and SBOs. And I think we should just draw that distinction.
Okay, thank you. I mean, a couple things. WMATA does have an oversight body that reviews cases. I asked them to look into the cases over the last 2 years where an SBO had a complaint against them. 0. There was 0 that the Metro Transit Police Chief found. So I just, again, as this assumption that all these police officers are up to no good, They had 0 complaints. The second thing is the procedural element. You're exactly right. It doesn't make sense to say you have to pay your ticket, but there's no enforcement mechanism, which is why the procedural elements that Councilor Lewis George's amendment seeks to strike are really important to include, because this is saying you have to pay your ticket, you have to show up if you want to contest it, which you're welcome to, and then it's an escalating ticket structure, just like if I get a speeding ticket. You can't just say, here's a speeding ticket, but okay, Brooke Pinto, if you never pay it, you'll never hear from us again. That's what we're saying now with fare evasion. That does not make sense. Again, we can't just wish our way into a different system. We have a fared system. 75% of people are not paying. There are other tools that we're deploying, like the new fare gates. Those have been helpful. But I don't think colleagues want us to put a Metro Transit officer on every bus. I don't think that's what this body wants. This is just supplementing an ability to issue those tickets.
Thank you. Councilmember Parker, for the record, I anxiously, enthusiastically, and eagerly await all the remarks of all of my colleagues. Just saying. There's no further discussion.
On this one,
Mr. Chairman, I would ask for a roll call vote, please. Thank you.
I have a question.
Councilmember McDuffie has a question.
Just quickly, Councilmember Pinto, if you have the answers to it, what are the differences between the training of WMATA police and SPOs who would be doing this?
So there are 2 types of SPOs. There's one category of SPOs that are WMATA employees, and then there's another category who are contracted out. The WMATA employees receive more training for de-escalation. Both are currently authorized to deal with the criminal offenses that Councilmember Fruman was talking about already, whether they're employee of WMATA or contracted. But I have an agreement with Mr. Clark to add 40 hours of training to all SPOs to address the concerns colleagues have raised around additional de-escalation to try to keep everybody safe.
But do you know this, like specifically what the differences between WMATA transit officers and the SPOs who would be getting this additional authority?
I mean, it's a different function. The WMATA Transit Police are more, they have more, equipment. They walk around in uniform and belts. They've got guns and tasers and other things that are akin to more traditional police officer, where a SPO is, there are many more women who are SPOs. It's over 30% of SPOs are women. They don't have tasers. They're a little bit more civilianized.
Is this an effort are there issues with cost? Is this a decision that they're making because it is less expensive to hire SPOs? Are they talking about hiring more SPOs? Are they talking about utilizing the SPOs that they already have as WMATA employees, or hiring additional contractors?
The latter. I have not been a part of any conversation that this is about cost. I have been part of conversations that the Metro Transit Police force is simply not large enough to address the overwhelming challenge of 75% of users fare evading.
Do you know what portion of their budget and how much it will be to hire the additional SPOs that they intend to hire to do
My
this?
understanding is these are all already hired SPOs because they already work on behalf of the system every day for the more serious offenses. They just don't have the authority to issue a civil ticket. They're not hiring a bunch more SPOs as a result of this bill.
Okay, and do you know, do you have any information or data around the number of encounters or how many citations currently are written by WMATA officers?
I don't know that number. I do know that many of the tickets issued have been ineffective because OAH had no ability to escalate the fine scale. Maryland and Virginia, for instance, charge $100 a ticket for fare evading. In DC, we don't do that. We debated that last year. It's $50, but if you don't show up, this gives you ability for...
Any idea how many additional encounters this would create as a result of us expanding the authority in this way with special police officers?
Encounters for the issuance of a ticket?
Yes.
I don't have that number. I mean, I guess we can back into the assumption if 75% of users are fare evading and we have, 10% coverage at stations, we could probably determine some number. And I would ask that colleagues with additional questions, that we can focus on that together between first and second reading, as opposed to striking the entire provision, which would disallow continuous collaboration.
Thank you, Councilmember. We have the amendment before us. I believe there was a request for a roll call. The vote is on Councilmember Louis George's and Councilmember Charles Allen's amendment. Madam Secretary?
Councilmember Bonds? No. Councilmember Bonds votes no. Councilmember Felder? Councilmember Felder votes no. Councilmember Fruman?
No.
Councilmember Fruman votes no. Councilmember Henderson?
Yes.
Councilmember Henderson votes yes. Councilmember Louis George?
Yes.
Councilmember Louis George votes yes. Councilmember McDuffie?
Yes.
Councilmember McDuffie votes yes. Chairman Mendelson?
Yes.
Chairman Mendelson votes yes. Councilmember Nadeau?
Yes.
Councilmember Nadeau votes yes. Councilmember Parker?
Yes.
Councilmember Parker votes yes. Councilmember Pinto?
No.
Councilmember Pinto votes no. Councilmember White?
Yes.
Councilmember White votes yes. And Councilmember Allen?
Yes.
Councilmember Allen votes yes. Mr. Chairman, there are 8 yeses and 4 nos.
Thank you, Madam Secretary. The amendment is approved. We have the bill as amended. According to my understanding, there are no other amendments pending. Is there any further discussion at 2:06 p.m. on this bill? Councilmember White?
Thank you, Chairman. So we, as a body, have a requirement to keep the city safe, and that's a duty that we can't overlook. We also have a duty to protect justice, and sometimes we have to weigh those two things. What I would say is, I have a lot of concerns about. I mentioned earlier the police training, but more broadly on pretrial detention. Before we passed Secure DC, about 4 months before we passed Secure DC, crime in the district started to decrease. And we have no data to show us that the expansion of pretrial detention has in fact made us safer. We do know that it has impacted justice, and when people are incarcerated as they await trial, innocent until proven guilty, they lose their jobs, they lose their housing. We also can't dismiss what is a fact that I think most of us would agree on, which is that there is not equal access to strong representation. And so the people who are more likely to have strong representation, when we change the rebuttable presumption and put that on the defendant, that's going to have a disproportionate impact on people with less means. Add on to that the fact that the attorneys representing the vast majority of people are understaffed by 30%, which means that the quality of defense and the time to get to trial is expanded. Add on top of that, and I should note that last summer they handled 800 first court appearances for people recently arrested. That was just last summer. Add on top of that the fact that we will have about a 22% judicial vacancy by the end of this year. Add on top of that the fact that our youth incarceration facility is already oversubscribed. So not enough lawyers, not enough judges, not enough beds, but more police, and changing the presumption. I think we don't have to stretch our imaginations to know how this ends. No matter what we intend, this is the reality. And when what frustrates me is there are things that we know and most of us wouldn't debate. We know that people of color, Black people, are not born more criminal, fact. And we know that many more Black people are in jail, fact. And when we always seem to have time and resources to address how to get folks in jail more quickly, but we never seem to prioritize the more urgent and more difficult thing of saying, why are there more Black people in jail? And what do we need to do to get underneath that? Instead, we keep adding on to this very broken system that is increasingly pushing people of color into incarceration and doing it so often, not with data, but with these notions of what is going to help, even when there's no data to support it. So I want to make sure I don't give the sense that we abdicate our responsibility to safety, but I do want to make sure we appropriately balance safety with justice, and we make sure at least we have data to back up the things that we do. And I don't feel comfortable that we have that data today. So I'm going to be voting no today, Chairman. Thank you.
Thank you, Councilmember. Further on the bill, Councilmember Nadeau.
Yes, Mr. Chairman, I'm about to leave to go chair my hearing, but I did want to say that I want to associate myself with the remarks of Councilmember White. I do have concerns about where this bill has ended up today, but my strongest concerns are around the pretrial detention. This is a very serious issue, and I'm just not comfortable with where the bill landed on that and expanding pretrial detention. So I am going to vote no today on the omnibus. Thank you, Mr. Chairman.
Thank you, Councilmember. Councilmember Parker.
Thank you, Mr. Chairman. I want to note on the last discussion about the SBOs on WMATA, I do want to work with you and Councilmember Pinto to think about the enforcement piece ahead of second vote, which I'm looking at those matters separately, and I think procedurally there's a pathway there. On this matter, I agree. DRS has its issue, YSC is overcrowded. That's and we need to address that. I would argue we need to address it in this year's budget. That said, this piece of this legislation is no different than what the council has already passed, and I think it is focused on the most heinous and violent acts, including shootings and stabbings. And so none of us want to incarcerate youth. I would also argue it is not helpful for that young person, their family, or our communities to allow violent acts like that go unaddressed. So as the chair of Committee on Youth Affairs, my team has really wrestled with this. We are continuing to lean on DRS. I invite my colleagues that have concerns to join us in this fight to improve functions of DRS. You raise very valid points. I think here, though, we do have to have a set of guardrails that say we will not tolerate violent acts regardless of your age. And I see that's what this bill doing. So I just wanted to put that on the record. Thank you, Mr. Chairman.
Thank you, Councilmember Parker. Councilmember Allen.
Thank you, Mr. Chair. I'll be brief on this. I do want to note, I think that Councilor Pinto made several adjustments within this portion of the bill. She outlined some of those, especially regarding elements where there's no physical violence or physical harm, which I think that most people will look at that and say that's probably not a pre-trial, because again, we're talking about somebody who's yet to be convicted of that crime. So I think those are some very thoughtful and reasonable changes that are put forward here. I do know some of my colleagues have some continued concerns around other elements of the pretrial detention portions of this bill. So I'm going to be voting in support of this today, but also be open-minded if some of my colleagues are coming with recommendations or amendments for second reading, because this is a portion that we want to make sure we get right, that it's informed by the data, that it's informed by what we've seen. Councilor White is correct. You know, we did start to see the decline in violent crime several months before Security C, but I also think we're trying to constantly find the balancing act here. And so again, I think that the changes that were made in here were some of the right ones, but I also know there may be more. And so I keep an open mind to my colleagues that might be working on amendments before second reading. Thank you, Mr. Chair.
Thank you, Councilmember Allen. Councilmember McDuffie.
Yeah, this work is tough. And I having chaired this committee, I know how tough it can be to try to strike an appropriate balance. What I do appreciate is my conversations with my colleagues, understanding that everybody prioritizes keeping residents of the District of Columbia and visitors safe. And I think that is the intention behind this bill. My issue, and I appreciate the outreach from Councilmember Pinto and her team and the committee to my office specifically on the pretrial detention provision of this measure, because I'm the one who raised a number of questions when Secure DC was passed, and I asked for the study to be a part of the bill. The challenge I have today, though, is that the study, and this is not to challenge the work that was done by the CJCC, but the reality is that there really doesn't appear to be any evidence that the study could share that pretrial detention component of Secure DC is making the city safer. That's the issue that I have. I can't tell you that it's making us less safe either, but my core is to bend the moral arc towards justice. And to me, the pretrial detention component of this bill does not bend the moral arc of the universe towards justice. It does the opposite. And that's the challenge that I have. So I do have a question, and maybe there's some light that you can share on this particular issue, or how you thought about this issue, Councilmember Pinto, because I know you have grappled with this and you've shared the communications with CJCC with me and my team, but is there any specific hard evidence that pretrial detention is making the city safer, that particular component?
So the correct timeline to
The
consider.
rebuttable presumption specifically, I'm sorry.
Yeah, I understand, and I appreciate that. I would say first, the correct timeline to consider is not after Secure DC, because the council made these changes in July of 2023, after which time we saw a precipitous drop-off of violent crime, the biggest delta that we had seen in years, right after that. Now, could you argue there are other interventions going on at the city at the time? Absolutely. I'm the first to say this is an ecosystem. We all need to work towards safety. I don't think there's ever one legal change that we make that fixes all of our challenges. But that is one piece of data. I visited and spoken to the head of our DC jail and DYRS about the population changes that they had seen, and the population that they were working with who were held pre-trial for the most violent offenses. They believed it was very effective. The chief of police felt that it was very effective in even just talking with her officers on the beat who saw repeat offenders who were not held before trial, and that was causing a lot of witnesses to not want to come forward because they felt fearful that if they did, the person would be back on the street. I've spoken with several of our colleagues, most of our ward colleagues, about situations that have happened in their ward that they were very upset about and wanted to seek a hold that was still not eligible. So as you mentioned, this is a balance. This is not a across the board, everyone is held situation.
Can I ask you a quick question? Because I know I'm running out of time and
Sure.
the chairman's pointing to it, and I don't mean to cut you off, but without the rebuttable presumption, the courts already have the tools to hold those who are charged with violent offenders, and those who I think under what's prescribed in the bill. Do you have data as to whether or not more people with the charges are being held as a result of the rebuttable presumption? Do you have that information?
So
No?
yes, that was in part included in the CJCC report, that more people are being held. That again increased greatly in the 2 months after we passed the emergency, but has been level in the last 21 months, both for juveniles and adults. But I laid out in the committee report about 12 reasons why these changes were necessary. It's not a bright line. It's not a requirement that someone is held, but judges themselves were telling me, before we passed this, we feel extremely hamstrung because even in the most violent of cases, child sexual abuse, rape, they weren't able to hold somebody. They weren't even authorized to hold somebody. So yes, I do believe that it is a very important tool in the sea of many tools, but that it would be irresponsible to not extend the presumption today.
If I thought it would make us be safe, I would support it in a heartbeat. I don't have the data that suggests that it makes it safe. Sorry for going over, Chairman, but this is.
Councilmember Lewis George.
Thank you, Chairman. Much of it has been said by my colleagues. The one thing I wanted to get a response to was just what we saw in the RIA. That's the only thing that troubles me. There's so many good parts of this legislation. So I commend Councilmember Pinto, especially the expanding the firefighter benefit, the training for safe passage workers. I think these are going to go a long way. Again, the RIA show good things on those aspects of the bill. But the RIA on this part of the bill regarding pretrial detention said expansion of pretrial for young people will likely exacerbate the harmful consequences of detention and imprisonment for Black youth, particularly around community safety, health outcomes, and well-being outcomes. It also indicated that it did not believe, and quoted, said basically expansion of the pretrial detention would likely, in addition to not sort of improving safety, could lead to more public safety issues. So I know I'm not sure if your team, I'm sure you have had the opportunity to read the RIA. I just wanted to see, what's your response to what the RIA is saying? And for those in the public, we're saying this, the RIA comes from our Council Office of Racial Equity, who analyzes our legislations for, equity and racial impact. So I just wanted to see, Councilmember Doe, if you had a particular response to what has been presented in the RIA regarding the pretrial portion of the omnibus. And again, there's so many good portions of this legislation. So that one particularly struck me when I read the RIA's sort of response and data in response to it.
Yes, I read it. I'd say it goes back to kind of what Councilmember White was talking about and the inequitable overrepresentation of Black residents in our criminal justice system. I think that that's true, not just in the pretrial detention population, but that's true in the regular committed population. And we as a city should invest a lot more resources in prevention and meeting basic needs and making sure people can live a sustainable, enriching life that does not lead to crime. What we're focused on today are elements of our bite-sized time in the justice system with the agencies that are within my jurisdiction, and that includes our correctional system. And so if somebody has committed a crime of violence, of rape or child sexual abuse or homicide, we need to be empowering our judges to consider that in their pre-hold. It is always able to be rebutted, and it is rebut all the time. I looked at a case yesterday. I won't even scare people with the elements that were going on in this case yesterday.
Are you saying that rebuttable presumption doesn't already exist in youth cases?
The rebuttable presumption did exist for certain cases of homicide. Oftentimes it was the second or third homicide. And for juveniles, we made smaller changes 2 years ago, which was like if there was a homicide with a knife, for instance, that was not included. We were very conscientious, especially on the juvenile side, to make our changes extremely limited. And we've limited it even further in today's version by taking out robbery where there's not significant harm to human life or second-degree burglary.
Councilmember, thank you.
Chairman.
It looks like there's no other discussion. We have the bill as amended before us. Councilmember Robert White.
Thank you, Chairman. To be very brief, prior to the changes in the rebuttable presumption, according to the CJCC report, 51% of people were held pretrial. So the judges can hold people, and I don't want folks to think that if this didn't pass, then murderers would be running around the streets. That's not the case. But we also have to remember when we talk about resources for prevention, incarcerating people costs money. So if we're going to incarcerate people with no evidence or data to suggest that it's making us safer, then this money is money that could be used for prevention. And so I need us to think about things like this as we pass legislation. Thank you, Chairman.
Thank you, Councilmember.
Just a brief second round, because I totally understand colleagues' desire for data. I've shared that desire across the board. But why is it that we need data for this one piece in such a firm way if we don't need data for lots of other programs that we have? I've laid out the metrics that we have looked at, but when we think about, I mean, I don't want to open a whole Pandora's box, as I can see I may be doing, but we've got a lot of programs that we all believe in that we are advancing without a direct line item of what happened before and after. And so I just ask for some consistency.
Chairman.
You did open a Pandora's box. So I think I saw, no, I haven't spoken yet, but I cited 8 different studies with regard to the college credits. Thank you.
Motion to close debate.
Yeah, there's been a motion to.
No, I have my mic on before the motion, Chairman.
There was a motion to close debate.
After I had my mic on, I called you 5 times.
I know, but I recognize the motion to close debate first.
I'm just gonna say, Chairman, that
Never.
the reason we want data is because this is about individuals' liberty interests, which is enshrined in our Constitution. And so while there might be other programs that don't have data associated with it, this one is about justice. It's about our criminal justice system, which in many cases has really done a disservice to people who have been historically discriminated against, people who are minorities, people who don't have wealth to pay for representation. And the reason that I asked for the study to be in the bill and to have data was because if there was data that showed that this provision around pretrial detention, rebuttable presumption made our city safer, then I would be the first to vote yes for it. We do not have that data, and this is about people's liberty interests, again, which is enshrined in our United States Constitution, life, liberty, and the pursuit of happiness. And in this case, we should not be holding people if we cannot demonstrate that it makes people safer and put the onus on them to prove that they should be released. There are already tools in the toolkit for judges to use to hold people. There's evidence that they were already doing that, and the majority of people who come for pretrial detention are held. And so I wanted to put that on record. I'm sorry, Chairman.
We will proceed now to a vote. The vote will be on Bill 26-187 as amended. All those.
And I request a roll call vote, Chairman.
Madam Secretary, would you call the roll? The vote is on the bill, Bill 26-187 as amended.
Councilmember Felder.
Yes.
Councilmember Felder votes yes. Councilmember Fruman.
Yes.
Councilmember Fruman votes yes. Councilmember Henderson.
Yes.
Councilmember Henderson votes yes. Councilmember Lewis George.
Present.
Councilmember Lewis George will be recorded as present. Councilmember McDuffie.
Please record me as present.
Councilmember McDuffie will be recorded as present. Chairman Mendelson.
Yes.
Chairman Mendelson votes yes. Councilmember Nadeau.
No.
Councilmember Nadeau votes no. Councilmember Parker.
Yes.
Councilmember Parker votes yes. Councilmember Pinto.
Yes.
Councilmember Pinto votes yes. Councilmember White.
No.
Councilmember White votes no. Councilmember Allen.
Yes.
Councilmember Allen votes yes. And Councilmember Bonds.
Yes.
Councilmember Bonds votes yes. Mr. Chairman, there are 8 yeses, 2 nos, and 2 presents.
Thank you, Madam Secretary. The bill as amended is approved, first reading. We will turn to emergency bills. I'm hopeful this will be fairly quick. The first is PR 26-219, Ninth Master Agreement between the University of the District of Columbia and the University of the District of Columbia Faculty Association / National Education Association Emergency Declaration Resolution of 2025. I'm moving this jointly with Councilmember Bonds. If the declaration is approved, then we will have the underlying resolution approving this collective bargaining agreement, which actually was reached a year ago, meaning August of 2024. It was approved by the Board of Trustees of the university in December. For reasons I don't understand, the executive didn't send this to us until earlier this month. The collective bargaining agreement covers the period October 1st, 2022 through September 30th, 2025. It includes a new salary structure for fiscal year 2025, a 3% cost of living adjustment for fiscal year 2025, a fiscal years 2022, 2023, 2024 promotion catch-up payments for eligible bargaining unit members, and a continuity pay adjustments based on years of service. The CFO estimates the funds are sufficient to cover the $14.8 million cost of this collective bargaining agreement over the financial plan. At the hearing or roundtable that Councilmember Bonds and I had last week, it was stated that as soon as this is approved, the bargaining will begin on the 10th master agreement. So moved with regard to the resolution. And is there discussion? You want to say anything? There's no discussion. The vote will be on the declaration. All those in favor say aye. Aye.
Aye.
Aye.
Are there any no votes? The ayes have it unanimously. We have the underlying resolution, PR 26-220, which is the 9th master agreement between the University of the District of Columbia and the UDC Faculty Association /NEA Emergency Approval Resolution. So moved. Discussion on the resolution. All those in favor say aye.
Aye.
Are there any opposed? The ayes have it unanimously. And the next measure, which is the last measure, is PR 26-225, Georgia Avenue Acquisition Authority Emergency Declaration Resolution 2025. Councilmember McDuffie.
Thank you, Chairman. This emergency legislation would authorize the acquisition of lots 809, 840, 841, 842, 843, and 848 in square 2937 located on Georgia Avenue Northwest. These 6 properties are currently underutilized, facing foreclosure, and are at risk of becoming blighted. It is in the best interest of the redevelopment of these properties for the district to acquire them and ensure a cohesive development process, especially considering the adjacent nature of the properties to a district-owned site, Engine 22, located at 5760 Georgia Avenue Northwest. In light of the pending foreclosure action on these properties, emergency legislation is necessary to gain control of these properties immediately for the benefit of Georgia Avenue corridor and to ensure that they are put to an economically advantageous purpose. So moved.
Is there discussion?
Mr. Chairman.
Councilmember Parker.
Thank you. We had well, I'm happy to yield to my Ward 4 colleague. It seems like she had her hand up, Mr. Chairman. Given that this isn't her jurisdiction.
I recognize that, but.
Okay, all right, I will just be brief. I was actually going to speak in defense of Councilmember Louis George. I totally get the rationale. I think it's defensible. It's a common sense investment. That said, for a ward-based council member to find out about this type of emergency days before a legislative meeting, to me seems woefully inadequate. And it is my expectation and hope that moving forward, should this be necessary in another part of the ward, we can do a lot better. And that DMPED can live up to its commitment to fully engage the community and the council member and her team on next steps. So thank you.
Thank you. Councilmember Louis George.
Thank you so much, Councilmember Parker. Thank you, Mr. Chairman. I wanted to address the Georgia Avenue emergency legislation introduced by the mayor. I've spoken to many colleagues about this. I didn't have a wealth of information when this emergency was added to this additional legislative meeting. And Georgia Avenue, as you know, is in the process of revitalization. I have anchored a Georgia Avenue revitalization working group, which is formed of 75 plus members of the Ward 4 community, including small business owners, as well as our main streets, to address the vacant and blight and revitalize Georgia Avenue. So when we found out about this, obviously we were excited, but we also felt like we didn't have enough time to really talk about what this would mean. There are several small businesses that are located in the current location that have leases. Businesses like Simple Bar and Grill, which is a neighborhood hub where people go and do karaoke, so you all can try that out sometime if you would like. You know, we have so many, the barbecue pit that is also located there. These are really local small business owners who are a part of the community, live in the community, and want to be a part of that conversation, as well as our advisory neighborhood commissioners of that area who also were not aware, who want to also be involved in the conversation. And so I appreciate Deputy Mayor Nina Albert for meeting with my team and I yesterday evening to discuss these things. My hope moving forward is that we will move forward in a way that will be allow us to support our small businesses, engage with our community members. I share the goal of acquiring these 6 properties facing foreclosure. I know that I appreciated that we have to move swiftly. And so for that reason, we're supporting it. This property also is adjacent to a district-owned Engine 22, which presents a real opportunity for cohesive development alongside the Georgia Avenue corridor. So I'm looking forward to continuing communication and working collaboratively with executive branch on this project and other initiatives. I'm optimistic about what we can accomplish together when we combine our shared vision with strong coordination. And I look forward to continued work. Thank you.
Thank you, Councilmember. Councilmember Pinto?
I meant to mention during the last bill that today is my committee and legislative director's birthday, Lynn Groft, and I just wanted to wish her a happy birthday. Thank her for all her efforts on this huge package.
Thank you. Okay. We have the declaration before us. All those in favor of the declaration say aye. Aye.
Aye.
Are there any opposed? The ayes have it unanimously. We have the underlying bill, Bill 26-283. Councilmember McDuffie?
The underlying bill, the lots square, Georgia Avenue, Ward 4. So moved.
Thank you. Is there discussion? The vote will be on Bill 26-283. All those in favor say aye.
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 Are there any opposed? The ayes have it unanimously. That's going to conclude the business of this meeting. The next meeting is scheduled for July 1st, 2025. The time is 2:36 p.m. and this meeting is adjourned.